Tonight, once again, we gather in search of the truth, dark, and mystery. It's the Drunk Turkey Show.
Big development today in the investigation into the murders of 4 University of Idaho students. According to state and local officials and court documents, 28-year-old Bryan Kohberger has been arrested. He was arrested and arraigned this morning in Pennsylvania.
We have new details on what Bryan Kohberger was doing right before his arrest. Police say as a tactical team burst in to arrest the Idaho murder suspect, he was in pajamas and latex gloves, stuffing trash into Ziploc bags.
Hey, greetings from the year 3000. It still sucks. This is Phil J. Fry, and you're listening to the Drunken Turkey Show. Your one stop for this sort of thing. Hit that button, like and subscribe. You know what to do, just like every other podcast.
What is up, everybody? Welcome back to the Drunk Turkey Show. I'm Daniel, and there's been some documents dropped in the Bryan Kohberger case, of quite a few of them. I went through them a little bit earlier today. Some interesting things. I think that we're going to end up seeing again, maybe a couple of hints or an idea of what it is that the defense is trying to do. Maybe some other tactics, maybe even some of what the prosecution's tactics are, and etc. But before we get into it, I want to welcome everybody across all platforms. We got the Facebook going on. We got YouTube, Twitch. We have X, Rumble, and TikTok all going on at the same time. So I want to say hello to every one of you guys on all channels. Thank you. Please comment, like, subscribe. Also on the YouTube side, I know I've gotten a couple of people tell me here recently that they're not getting the notifications of when we're going live. One thing that I can say and recommend is make sure you like the content. If you hit the like button, you give it the thumbs up. That tends to tell the YouTubes that, hey, this is a creator or a channel that you definitely want some contact with, and they'll be able to help you out. All righty, guys. Let me kind of adjust this. I got my camera here. I just realized that my TikTok camera is kind of in the way, but it is what it is. All righty. And so, again, as I said earlier, we had a couple of documents drop. And, well, first and foremost, I also want to thank Midwest for becoming or for being a member for a month. I hope you're doing well. Thank you for your 1-month membership. If you guys aren't members yet, make sure to go and hit the join button in the description. This is going to be on majority of the platforms, but this is for the YouTube side. YouTube members, we'll do usually about a 1 or 2 member only lives a month. I haven't done one yet for the month of February due to the injury to my arm. I do plan on doing that. Maybe even this weekend or in the next couple of days, get that knocked out. That way we can, get it for the month. I know I've had some issues with my arm, but I'm over the hump there, so to speak. So just kind of give everybody an update. I went and got the wound change done today. They looked at the injury to my arm, and they're telling me that it's looking really good. Our members, you get a Discord link. So I know we put up some pictures earlier on the Discord. If you guys decide to join, I'll put a link after the show for the newest members to join the Discord. We can contact myself, and you can also have a conversation with all the other members. You guys it's an amazing conversation there. You guys, it's an extension of the show, so to speak. You guys don't want to miss it. All right. So with that being said, let's break it down. Let's get into this. We're going to start off first with the fact that there were about what is this? 6 different documents that were dropped in the Bryan Kohberger case. And we're going to start off with the state's motion in limine, admissibility, demonstrative exhibits, and memorandum in support. And so this one's going to be a state of Idaho document. This comes from the state of Idaho. Respectfully moves this court for a pretrial order regarding admissibility of demonstrative exhibits. State will seek to introduce a 3-dimensional model of the 1122 King Red residence for demonstrative purposes to aid witnesses in their testimony. And so this is basically referencing how the state is going to build, as I said, a model of the home. I know there was a lot of controversy that went on about how and why the house was destroyed. I, for one, wasn't a fan of it. I didn't think that it should have happened. I would have liked to have seen it stay until trial, just for whatever reason, in case, or, you never know, right? It's like better to have it and not need it than need it and not have it, so to speak. And so, with that being said, we've seen pictures. I've seen some pictures of certain parts of inside of the house that have been put out there. Some may have been sent to me. And what you notice when you look into it, or even when they were demolishing, there's some video where they were demolishing the house and they took out one of the exterior walls. You notice that in the inside of the house, a lot of it was also removed, and that was with good purpose. They were looking for DNA and evidence all across that place. And so the stairs were taken out. So if somebody wanted to go into that house and try to walk and see what it felt like, or see what it was, to retrace the steps of the killer, it was impossible to do, even if they kept the house there. The stairs weren't there. Majority of the walls weren't there, especially in the victim's rooms. You can see in Maddie's room, there was several pieces of the drywall that was taken out of that room as well. So there, when you break it down and you look at it in its totality, it just didn't. There was a lot of chemicals. There was a lot of things that were missing. It was probably unsafe to have people going in and out of there. And, I think that that's probably the main reason why they ended up tearing it down. It wasn't going to be usable. And, like I said, for good measures, they were going to end up having to, they were going to have to end up taking everything out. There was nowhere to go and walk in there. And also, guys, at this point, I'd like to encourage everybody. It's telling me here on the TikTok to encourage everybody to share the live and invite more friends. So I'm going to take that to all the platforms. Please share this out your friends and family. Would appreciate that. If you're listening to this on the replay or an Apple or podcast or wherever you get your podcast, please do share this. We'd appreciate that. All right. So the primary purpose of this model, and this is what the argument says, is to aid the jury in having a better understanding of the layouts of the residence, which is unconventional, and to illustrate where certain events occurred within the residence. This model will aid certain witnesses. Now, I think also what this model is going to do is it's going to help aid, and we're going to find out in a couple of documents here when we speak about the alternative perpetrator or other persons that may have committed this crime, is the fact that we know that one of the arguments from the defense's side is going to be that there were potentially other people that were involved in this case. They're going to look at the DNA blood samples that were found in a glove outside and on a handrail off of the first floor staircase. And this model is going to be important to show you where that blood spot was, that speck of blood that they found on the handrail on the first floor, which I told everybody here. And, I hate repeating myself on this, but I did tell you guys this a couple of weeks ago before that information came out. I said that I knew it was going to be on the first floor. And I said, what are the Kohbergers, or what are those that think he, are coming up with excuses for him to claim that he didn't commit this crime? What is the excuse going to be when we find out that DNA sample was on the first floor? I said this for weeks. I've said this for a while, but more notably, where you guys can go back and watch and show for yourselves and see it. I said it about 3 shows ago. I'll put it in the community tab where I said, what are you going to do with the date before this came out? What are you going to do when this comes out that this is the case? And ended up being that indeed it was the case. It was a speck of blood that was on the first floor. And when you break down how police trace this guy's footsteps, right? We know there's latent footprints. We know that there's sounds. We know that there's audio. We know that there's a phone that's involved where somebody's awake, which is Xana, that she's up until 4:12 in the morning. We know that there's a witness awake that hears certain things and sees certain things. And so the law enforcement is going to be able to paint a picture of how and what happened. That picture is probably going to sound a lot similar to this. Bryan Kohberger parked into the rear of the residence around 4:06 to 4:07 a.m. approximately, entered through the rear sliding glass door, walked up to the third floor, entered into Maddie's bedroom where he saw both Maddie and Kaylee laying there. Kaylee laying on the inside of the bed with against the wall, Maddie on the outside of the bed towards the room, and that he struck and attacked probably Maddie first and then Kaylee, who ended up in the corner. From there, Xana heard or may have felt a draft left from the sliding glass door that was left open. And I believe, since Dylan stated that she heard who she thought was Kaylee going upstairs with Murphy, I believe that during the initial entry point and while the commission of the first murders were happening, Murphy may have gone down and to Xana's room. Maybe that's what alerted her. Maybe it was the draft, but she ended up coming out and going upstairs, figuring out that somebody was in the home, turning around, going downstairs, saying, I think somebody's here, runs to her bedroom. The perpetrator, who's allegedly Bryan Kohberger, follows her, goes into the bedroom, and then I don't want to say struggle ensues because there is an audio from 50 feet away. And although it does describe and use the word struggle for less than a minute, it doesn't sound like that is the case when it comes to, the PCA and things like that. It sounds like they say they hear a thud and some noise and some mumbling and some whimpers or whispers, voices. It doesn't sound like, kicking, screaming, punching, throwing, person landing on multiple walls or any of those type of things. And so the person came, during that time, we find out from the documents that Murphy is barking outside. So Murphy is outside barking and the perpetrator is inside at the same time. And you can hear the struggle for less than a minute happening at the same time. Then that would make, a reasonable person to believe that the sliding glass door in the rear of the house remained open for him to exit and then to also enter back into the home, as far as when police ended up finding him. And, we're going to end up hearing something like that. Well, during that entire process, did he ever go down to the first floor? And the answer is no. Now, what do we know happened just recently up until the point of this this incident? The night before, the houses on that block had a huge party. Over 150 people were going in and out of each individual house. It doesn't necessarily mean that at one point 150 people were inside the 1122 King Road residence. What it means is that at one throughout the entire night, 150 people passed through there. And so you may have had at most at one time, maybe 20 to 30 people, but you have, 6-7 houses in that area, and people are jumping from one house to the next and going back and forth, et cetera, et cetera. And so you're going to find a bunch of things inside the house, a bunch of DNA. And we know it wasn't very well cleaned because what do we know the night of the incident? Everybody in that house was gone until about 2 a.m. That's when about everybody returned home. And we see pictures of what looks like a party inside of the house, or the reminiscence of a party. You have a beer pong table, you have a bunch of beer bottles and food and other items throughout the entirety of the home. So we know that they didn't clean up that house. Let me rephrase that. We know that they didn't do an extensive cleaning of the house that would have taken away DNA or any of those things. So we do have to go into this crime scene knowing that there's a crap ton of DNA all over the place that may have gotten there before the actual crime was committed. And if that ends up being the case, which is the case, then that's why they're looking so hard at the knife sheath. The reason they look so hard at the knife sheath is because that item was not part of the party and was brought in by the murderer. So put it all together, that's the main reason why they're looking at the knife sheath. And this is why they're looking at utilizing this, or one of the reasons. I'm sure there's multiple reasons. They're going to try to determine, how complex this was. That, I would assume, and you guys can probably let me know in the comment section as well, that maybe some sort of knowledge of the interior of the home, which would speculate to somebody either watching or doing their due diligence of planning this ahead of time, without having to say that they did that, right? Because we know, and the defense is going to say there's no evidence of stalking, this, that, and the third. But when you bring out the model and you say, hey, look, he went directly here, went here, and then left through here, never went downstairs, never did this, didn't check that door, it seems like it's a targeted event, which is another reason why they probably said it was a targeted event. Because you have a individual who was between two scenes, right? And that was Dylan's bedroom. That was you would have had to have passed Dylan's bedroom to have gotten to both Maddie and to Xana's room multiple times, and to have left. And so I think that's one of the reasons maybe why they had said early on that it was targeted. And although not necessarily wrong, I still don't think that they can tell who is the target, if it was one of the female victims or Ethan or the house itself, and one of the reasons I think that they put the house itself is because the house could have been a place where a killer could say, hey, there's a lot of people that are going in and out. I can hide my DNA. I can hide my footsteps if I wear things like Vans shoes that are commonly worn by college age students and persons. I can mask my entry and exit through this. Obviously there's no such thing as the perfect crime. And him knowing that, given the fact that in his studies as a criminal justice student, all those things play a role. And when you're trying to commit the perfect murder, you're going to have to look for the perfect place. And if you have a bunch of victims or a bunch of persons going in and out, leaving DNA, and you're able to mask yourself amongst it with some clever planning and things of that nature, I'll be honest, if he didn't leave the sheath behind, he probably would still be a free man. All right. And hey, how's it going? I'm seeing a lot of folks on the Twitter giving some badges and things of that nature. I hope you guys are doing well. On the Twitter, on the TikTok. So hello guys, I'm waving at you. Thank you guys for joining, and for everybody else, I think I didn't forget about you guys. You guys are doing amazing as well. So I'm going to go through these, and then I'll at the end I typically answer some questions and super chats and things of that nature. Target of opportunity is what A and Z says. That's quite a possibility, but I will be honest with you, the fact that he drove so many times throughout that night around that house, I think that it just kind of screams to me that was the target. Now, could he have had other targets? Potentially, but I think this is the one that he wanted to go with. Let's see. All righty. And we're going to get to that too, Mark. We're definitely going to get to that. All right, so let's go to the next one. The next one is the state's motion in Lemon. This is referencing the alibi. Now comes the state of Idaho and respectfully moves the court in Lemon for an order prohibiting the defendant from presenting any evidence, whether by direct or cross-examination, in support of any claimed alibi other than from the defendant himself. So they're wanting him to go up there and say, all right, where were you? You can testify. There's nothing that's, they can't stop him from, testifying and speaking, speaking on trial or going on the stand. I don't know if he'll do it. I know a lot of people have asked me, like, hey, do you think he'll get on the stand? I don't know. Part of me has always said, maybe if he's that narcissistic guy, that he's going to try to go out there and try to, be the smartest person in the room. But you look at some of the actions of Bryan Kohberger. We know that he allegedly committed the crime, and then later on that morning at between 9:12 and 9:30 went back to the crime scene. Now, there was nothing on the news or anything out there because the bodies weren't discovered yet. Now, does that give you a sense of comfort knowing that the bodies haven't been discovered so that you can go back out there? Because, him being in criminal justice, one of the things that he would have known is the fact that a camera would have been set up when the bodies would have been discovered, and this would have been considered a crime scene and it would have gotten contained. And those cameras would have been detecting license plates that are going to be going in and out of the area to try to capture anybody going back to the crime scene, revisiting it as he did. Me personally, I think he had some sort of dispatch radio of some sort. 911 in that area was all handled by Whitcomb 911 in Pullman, Washington. And that included WSU. So if he were to have gotten his hands on a WSU officer's dispatch radio or login information or something to that nature, he would have had access to all of that area's dispatch. It's just a change of frequency. So like, for instance, when I was in law enforcement, I could change the frequency and I could hear the troopers. I could hear the sheriff's department. I could hear the school department, or the school systems, police departments, and the university campuses police department. I also had a button where I could hear all of them at the same time. It was open. So, well, this also was, again, over 10 years ago now. And so, things have changed. So I'm not entirely sure that they're the same. Since I was in law enforcement, but going back that long, that's how things were then. And I can see how, if you had access to one of these things, especially in a smaller town where you're getting not the most up-to-date and technology equipment, I can see them having some outdated stuff that still works on that same format. And if he had one of those, I mean, that would give him the comfort of going back out there to revisit the scene, knowing that the scene hasn't been discovered and that there would be no cameras or any of those things set up. It made him comfortable enough to go back without turning off his phone. And according to the documents, it wasn't just a mirror in the area. It stated that he returned to the scene. So I'm interested in that. I mean, here's the other thing too that's really weird, right? So, or not necessarily weird, but he returned to the scene. We know that the back sliding glass door was open. We know that the doors to the Maddie and Kaylee's room are open. I'm not necessarily certain if the door to Xana's room was open or not. The documents kind of say, when they refer to the doors, all the doors open. The back sliding glass door, they kind of acknowledge. But some of the other stuff, it stated the word, I think it was what against what the evidence is saying. It kind of used that phrase there. So I'm not necessarily certain if Maddie and Kaylee's room or if Xana and Ethan's room was in fact open or not. I would have assumed so, given the fact that it appears the other ones were left open. I would have thought he would have followed the same MO. But I don't know. I can't tell you. But now let's go back to this document. This is the about the alibi. So this one goes: the state of Idaho respectfully moves the court in limine to order prohibiting the defendant from the alibi unless it's from himself. I'm sorry about that. And this talks about the background of when the state has referred to having the alibi. And the alibi was supposed to have been sent in or been completed by May 23rd, 2023. Well, the request for disclosure alibi demand was May 23rd, 2023. So we're going back almost 2 years ago. State's July 2023 motion to compel. And then it continued to go on, and they have 10 different instances of different times where they have talked about the alibi. This document continues after that. It says, now been approximately 20 months since the state made its request for disclosure for alibi demand. The defendant has yet to specify the specific place or places at which the defendant claims to have been at the time of the alleged offense, and the names and addresses of the witnesses upon whom he intends to rely and establish an alibi, as directed by February 23rd, 2024. What this also means is that Ray isn't going to say where Bryan Kohberger was during the specific time of the murders. Now, what we do know he's going to say is that he's going to say that at 2:54 is when Bryan Kohberger's phone turned off, and at 2:54 he was headed southbound towards Bugsby, not towards Moscow. What they don't fail to realize is that there's multiple routes that'll lead you back to Moscow and have you there within plenty of amount of time to get him in front of the camera at the 700 block of Indian Hills Drive at 3:20, was it 3:27 a.m., somewhere around there. So, the distance between where his phone was even at Bigsby or whatever it was called, I think that's what it's called, even if he was there and his phone turned off, it's still only, I think, about a 15-mile drive for him to get to a place. What is that? Almost 40 minutes away. And so it's not impossible to get there. In fact, he could have driven around the entire city of Pullman and gone a different route and come in a different way and still made it there in time, within time. So with all that being said, the mere fact of him traveling southbound out of Pullman at 2:54 a.m. is not exculpatory, or does not is not without the realm of possibility of him being able to accomplish, if that makes sense. All right, let's continue. Even were the defendant to attempt to comply at this point in time, the state irrevocably prejudiced. It has now been over 2 years since the homicides occurred and since the defendant was charged, and it would be unrealistic at this date to expect the state to effectively investigate and respond to any new additional alibi-related disclosures. This precisely the situation that caused concern for the Idaho Court for Appeals in the state versus Juarez, as well as concerns with the United States Supreme Court in Williams versus Florida, where the court noted and this is in quotation, ease with which an alibi can be fabricated. And that's the whole point, right? The whole point of the state getting the defense's alibi before the state has to drop their discovery is in efforts to avoid a fabricated alibi. If we go back to the Murdaugh case, where in there, Murdaugh gave his story and spoke about what had occurred prior to him finding out of the Snapchat video that completely dismantled his entire story. He said he wasn't at the dog kennel, that he had left, and this, that, and the third, and yet his son has a Snapchat where you can hear his voice in the background. Now, I hadn't watched much of the trial, if any of it at that point. I didn't get into what happened with Alex Murdaugh in that case until after he was convicted. Until about that time, to be honest with you. I started watching it when he was testifying. I had no knowledge of anything else. And when he was going up there and he was saying how he went down there and that there was this that happened, there was a dog that chased this, and that's why he was there, and he left this way, I thought it was completely feasible. I had no knowledge that he had made some other story up earlier. It wasn't until I found that out, and then I was like, oh, okay, well, then obviously this guy is lying. But that just kind of tells you that once you know what the prosecution knows, because let's be real, that case, this case, or majority of cases aren't on video. They're not recorded. There's going to be an opportunity for somebody to come in and say something that is plausible, that is fabricated. You can fabricate something within that time frame. And so that's one of the main reasons, and a huge clue that the defense isn't being very honest, right? Or maybe not honest, or the defense. I mean, how can you feel that comfortable with as a defense attorney and your client if they're unwilling to tell you where they were during that time frame? Because even Ann Taylor doesn't know where Bryan Kohberger was that evening. And how does that make you guys think or feel? And the reason I say that is because there's a transcript that's associated with this. And there was a hearing, and I'm assuming this hearing was in secrecy. So went in here and I highlighted some things here. And this is in referencing the alibi. It says here, and this is Mr. Thompson in this hearing. It says the court says, or the judge would be, it says, okay, so the next motion, I believe, is the state's motion to compel notice of defense of alibi. Mr. Thompson says a few words. I'm just going to talk about the highlighted portions. It says, Mr. Kohberger has at least now stated that his alibi is he was out driving around that night. We knew that already. And if that is his alibi, so be it. The defendant has still failed to do is to comply with Idaho code. that specifically requires the defendant to provide identity, to identify the names and witnesses who will be called to support the alibi along with their addresses. Let's see. The state's position is at this point is we will accept that the defendant has said that he was driving around, although he should specify where he was driving. If he's not going to call anybody else, if he's not going to offer evidence from anybody other than himself, and that's none of our business, so we are willing to accept that. With an order from this court prohibiting the defense from offering a third-party evidence, whether by direct cross-examination, in support of the defendant's claimed alibi. And the reason they want to do this is, like, let's just say they find a video, right? And this is the defense. They find a video of what looks like a white Elantra near the Walleye Park. And they hold on to it. And then they bring it out at the last minute and say, hey, look, no, here's evidence that I was out there. Here's my proof I was there. Here's a trail cam picture of what appears to be a white Elantra out there. Well, that doesn't give the state or the prosecution enough time to go out there and investigate if that white Elantra was Bryan Kohberger's Elantra, if that was a white Elantra at all. You know, there's a lot of things that they can't go in there and determine. So they want to make sure that they have all the evidence and everything that they're going to say within a certain amount of time so that they can prepare for those things. Okay, and so let's continue. This continues to say, if he wants to testify to that, that is his prerogative. But at this point, it is too late for the defense to comply with the statute and identify specifically people and their addresses who will testify. And then he brings on Miss Taylor. And she goes, Thompson is right. We don't have to tell the prosecutor if Bryan is going to testify or what Bryan might say. So we don't know if he's going to testify. It's a little bit of a clue. I don't even know if she knows what Bryan might say. She goes into saying, I don't have documentation to give the state today. I'm not going to go into it any more about it at this moment. I understand when October 2nd is. I definitely understand that, and I have heard everybody's thoughts and concerns. I get that, but I mean, this is what we have, and when there is more, I will provide it. So this is all she has. She has no more. She does not know more about what Bryan Kohberger was doing that night or where he was. So even she has no idea where Bryan Kohberger was. Now, why do you think that is? Do you guys think that is just because she asked and he said, I don't want to tell you, secret mine or something like that, I doubt it. Or could it be like, hey, do you think that conversation may have gone like, if you don't want me to know where you were that night, then don't tell me. And if that's the case, because that's kind of what it sounds like, well, she don't know where he was at that night. So that must mean, in my opinion, just kind of connecting these dots, that he was probably somewhere that she doesn't want to know for sure from him. Hope that makes sense. Okay. All right. They go on a little bit later, and then the court goes on. All right, thank you. Well, the way I understand this is, and this is in the so-called alibi, not really an alibi, but, quote, he was out driving during the late night and early morning hours of November 12th to 13th, 2022. So what I'm going to do, because the next motion is for scheduling orders, I'm going to address this in the terms of a deadline, and we'll see how that goes. Right after that is as far as Mr. Kohberger wants to go with. To regard with the alibi is fine, and then they talk about setting a date for that deadline. But again, as I mentioned before, even at this moment here, not even Miss Taylor knows where Bryan Kohberger was that night. Let me rephrase that. She probably knows where he was that night. But she has the excuse to say that she does not know where he was that night, that he has not disclosed that one way or another, which isn't, in my opinion, the strongest thing. All right. If you find out that a defense attorney doesn't know where their client was that night, or the client don't want to tell them, it's usually for a good reason. All righty. So the next one is the state's motion in limine alternative perpetrator evidence. So it comes now the state of Idaho and respectfully moves the court in limine for an order prohibiting the defendant from offering alternative perpetrator evidence or argument without first satisfying the court that such evidence is relevant and admissible pursuant. So they don't want to allow the defense to just go in there and say Bill, Ted, John, Jim, and Jake all committed this crime, or whatever the case may have been, or one or the other, without any actual proof or evidence or anything like that. I know that one of the more recent cases that had something like this was the Delphi case with Richard Allen, and they didn't allow the odinist theory. That was one of the recent things. That's kind of similar to this. I think they're going to try to say that there was other suspects. If the prosecution, which I think they did, because it sounded like they did in one of their more, it was more recent hearings. It was one that was probably about 6 months ago now. They spoke about how they had some DNA tested at the request of the defense. And the only DNA that the defense had been requesting or talking about or referencing was the two unknown DNAs that they had, one in a glove and one somewhere else. We found out later was on the first floor staircase. So, so take that for what it is. If they go in there and let's just say they try to say, well, there was a second perpetrator. We have this blood evidence here. The state can come in and say, yeah, we've done the test. That blood belongs to, John Doe, and he has an alibi. And so you can't throw him in there. He already has an alibi. He's been cleared, or whatever the case may be. But this goes on to say that the second step is to determine whether probative value of the proffered evidence is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considering the undue delay, waste of time, or needlessness of presentation or cumulative evidence. And we've seen that a lot, where the defense has been somewhat accused of fluffing everything, right? I mean, they've gotten warning, so to speak, by the judge with the amount of papers that they have in their proceedings or in their motions, and how some of it is irrelevant and repetitive and not needed. And so they've already gone through wasting the time. They've already gone through of doing a stall tactic, clear stall tactics throughout this entire time. You would be, in my opinion, it would be foolish to think that they wouldn't try to delay further. In this case, during the course of the investigation, literally thousands of tips regarding possible perpetrators were received by law enforcement. With the exception of the information regarding the defendant, none of these tips were substantiated. So of all the tips that they've had, there's only been one person who fits all of the evidence, and that is the defendant, obviously. So we'll see how that works. If I had to do a prediction of how that's going to transpire, I don't know. Probably not. I think they'll probably allow them to say that there was an alternative perpetrator. Some of the alternative perpetrators that we might hear of are going to be, obviously, I think Jack DeCourse probably going to be one of them, being the fact that he was the ex-boyfriend of one of the victims. He was with two of the victims that night at the corner club, and he was the person that was called multiple times, plus the how close in vicinity where he lives is very close in vicinity to the victim's residence. So those things compiled together, although he was cleared, I wouldn't be surprised if we hear some things about, we hear the defense going after him. That's something that I had spoken with Christy Goncalves about on an occasion, where I was like, hey, I feel really bad for Jack. He's going to have to be strong, because they're going to probably come after him the most. And she understood that, at the time when we talked about this, she said, yeah, and she knew, and she felt really bad because he's a really good kid and he's going through a lot. I mean, he lost the love of his life in a very horrific and traumatic manner. And, it's heartbreaking. It's sad. And now they're going to attack him as if he was the person that may have been responsible for it in efforts to get off the person that really did commit this crime. And so, and you're going to have some people that are going to be backing him up and doing those type of things. And I just feel kind of bad for the kid, but they're aware of it. They know about it, and they're going to be strong about it. And so I think that his testimony is going to be strong as well. Now, here's an interesting one. So this is the state's motion in limine for the neuropsychological and psychiatric evidence. And so apparently, Bryan Kohberger may have seen somebody who has some has an idea of, or some evidence that may play a role in this case when it comes to Bryan Kohberger and his defense. So it comes now the state of Idaho, who respectfully want to move the court for an order in limine prohibiting the defendant from offering testimony regarding neuropsychological evaluation and psychiatric evaluation of the defendant as summarized in the defendant's January 23, 2025. And so this is an evaluation of the defendant. So it's not an evaluation of anybody else. This is Bryan Kohberger's evaluation. And let's see. Supplemental response to request for discovery regarding expert witness. Specifically, the state objects to the proposed testimony of state witness identified as in defendant's exhibit D7 and D13 appended to defendant's supplemental response for request for discovery regarding expert witnesses. And this in support of this motion, the state respectfully refers to Idaho Code 18207, which provides that mental condition shall not be a defense to any charge of criminal conduct, except expert evidence on issues of any state of mind, which is an element of an offense. And what that is like a crime of passion, right? So if, for instance, now I'm not familiar with everything in Idaho, but in Texas, if a guy walks in, or a person, because it could be a female, if a person walks in on their spouse cheating, and in that moment of rage, commit an offense, the offense is actually dropped down a charge. It doesn't mean that they're going to get off on it. It doesn't mean that they're not going to go to jail or anything else, but it goes from first degree to second degree murder, those type of things. It drops down a level of charge here. Now, it sounds like, based on what those words and the reason why that the defense or the prosecution is using this evidence here or trying to get this thrown out is based, and this is the reason why they're getting it thrown out, is because in Idaho, you can't use this as a defense. This, to a certain extent, almost feels like they're saying he's guilty. That he did it, right? I mean, you don't use these expert witnesses saying he did it because of, he had a mental issue. Right. And when I mentioned that other part about the spouse and stuff, that was referencing the part where it says specifically state accepts part. The accept part is the one that I think that's how it is, because that's what it is in Texas. Idaho could be different. Everywhere else is different. But it seems like the defense is going to try to utilize this information in support of Bryan Kohberger, and the prosecution doesn't want it out there because they can't use this as a defense. To me, this kind of says he's saying he did it, and that he did it because he wasn't in the right mindset. You know what I mean? This basically tells me that they have a defense of a mental issue as far as why he committed the crime. You can't have this defense unless you commit the crime, right? You can't plead to something you didn't do. And this is saying he did something based off of this. So in each of the witness summaries, the defendant specifically states the testimony is not intended to be a mental element defense pursuant to Idaho, but rather this testimony is about the state of mind, as well as factual defense testimony as anticipated testimony elicited by the state, as such as proposed testimony falls outside of the mental conditional evidence allowable under Idaho code. So this could be also the mitigation part where it comes to the guilt phase, and the state doesn't know. Are they going to use this witness as a mitigation or as a an expert witness during the trial? And so they're going to cover and cross their T's, dot their I's and cross their T's by saying, hey, if this is some sort of expert that's going to say that they're innocent due to some sort of mental condition, then we're going to want this thrown out as far as that goes. Now, I think that they're going to be able to use this into the mitigation aspect when it comes to the factors in which a person is to put to death, right? There's got to be a couple of things that they need to pass through. I think they're called agitators that need to be done. And does his mental health and mental status, is that a reason to do that? To not have the death penalty, right? To drop the DP, so to speak. A lot of other persons and people out there who are more knowledgeable about law, like some attorneys have mentioned that this type of defense or this type of action by the defense is usually stuff that is occurring when a plea is going to be is the next step, right? They go in there with all this information and say, hey, we're going to try to get this taken off, blah 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 blah. We'll plea out if you take the DP off. I wouldn't be surprised if that's going to be the next step, is that we're going to get a plea deal. And there's been a lot of defense attorneys, and I was surprised about it because there's been defense attorneys who have spoken about this. Nothing against defense attorneys or anything like that, but I've seen a handful where it's just no matter what, everybody is innocent, no matter what, everybody's everything. And these aren't people these aren't clients that these defense attorneys are defending. These are just, other persons. And it just, I hadn't felt comfortable watching a lot of defense attorneys talk about a lot of different cases. Surprisingly, I've seen a lot of them say that this is what is the first couple of steps when you find a plea deal going on, or the start of it. Interesting stuff. And I'm almost done, guys, and I'll be able to get to your guys' questions here in a second. In fact, I think I just got 2 more. So I think that's the biggest, to me, and the other 2 are going to be small. There's going to be a motion for leave to exceed the page limit. And now this is for the defense. So now comes Bryan Kohberger, and they want to go past the 10-page limit for their motions for improper disclosure of expert test or improperly disclosed expert testimony. And then also referencing Ryland Nolan and reference to touch and contact DNA, witness identification by bushy eyebrows, and motion limit for conditions as aggravator. So that's going to be the last one, the conditions of aggravator that we had mentioned earlier about the death penalty too. So that there it pops its little head out again. And then the last one was the court granting the order to exceed the 10-page limit, but not to exceed the 20 pages per motion. So that's where we're at there. Now I can answer your guys' questions and comments. If you guys have asked a question before, I would please ask it again. That way I can, I'm not going to go all the way back up to the top and go forward. All righty. So let's go to the ones that I had started off already. Steph C on YouTube says there's no evidence of stalking as defined by Idaho law, where the victim has to know it's happening 12 times by the house and other indicators that it was unofficially stalking to them. I don't know. I mean, they made I'm an honest person when it comes to things. I know a lot of people say that I'm biased or whatever the case may be, but I'm really not. I'm a very straight shooter on this case, and on every case, I really do try to be. And when it comes to that I could have swore in one of the documents and in the court, it alluded to the prosecution saying that it didn't sound like he was stalking him. It sounded like he was going to other places. And so I don't know. It definitely felt like the 12 times. It felt like that's what they were trying to say. And I think that was one of the arguments from the defense's side. But when it came back, the final ruling on it, I believe it was that they didn't know at the time that he wasn't that close to the house. And so at the time of the warrant, you can't throw it out. You can't throw out the warrant due to the fact, because the argument was that they wanted the warrant thrown out because they made it seem to the magistrate that he had been traveling around there 12 different times and stalking them. And they basically the answer of the judge was, even though they were wrong, they weren't purposefully wrong. And he did drive by 12 times. And that at the time, based on the information they knew, they went based off of that. And so I think that was a lot of their argument on a couple of things like that, and the lack of DNA in the car and apartment and stuff like that. Those were the arguments that at the time of the arrest, they weren't aware of those things. So they couldn't have told the judge that. And so that's kind of where that was at. But I don't know. I just don't think that that's going to be the case. I do think he ended up stalking him. I would be lying if I said he wasn't. I wholly believe he did. I just don't know if there's any proof of it. And I'm not sure we're going to find proof of it. Idaho doesn't have an insanity defense. Nope. Anytime there's an insanity defense, there's an acknowledgement of guilt. You don't claim insanity if you didn't do anything. Idaho doesn't have an insanity defense. And then Rebecca says, thank you, Daniel, for inadvertently answering my question. Not sure what the question was, but if you want me to answer it, let me know. Let's see. I'm pretty sure that Bill Thompson said that he would be seeking the death penalty in this case, meaning no plea deal. I mean, they can say that. Saying that and doing it are two different things, right? He can say we're going to go this route, and that could just be added pressure. But at any point, I mean, the trial could start. They could be deliberating. The jury could be deliberating, and a plea deal can be put in place. Wicked comes in and say, do you think there's a plea deal coming? I think the talks of a plea deal is coming. I don't necessarily know if a plea deal will happen. What is your take, corporal punishment? What is your take on BK bagging clothes and weapon and putting it all in a dumpster outside 1122 because he knew the garbage collection was that morning? I don't think he did that. If I would have had to have taken a guess, I think it was probably somewhere along that road that he traveled that first day. And then remember, he went back out after he went to the scene. He went back home. Then he went to, was it Clarkson, Washington? And then on the way back, he turned his phone off again in Johnson, Washington, and was in the area where his phone was off the night before. And so I think he was either moving, hiding, reliving, doing a bunch of different things with the items that he had. But I think that's where those items were. But it definitely could have been. He could have turned off his phone from right then and there and then gone all the way back to the victim's home, driven around there, revisited the crime scene that day with his phone off, and then didn't turn it back on until he got back home. Very much possible. He was out there for like 5 or 8 hours or something like that. I think it was like from 12 to 8. So almost 8 hours, something like that. Hi, Dan. Do you think the 8-hour delay to call police is exculpatory? I don't see how that would be exculpatory to Bryan Kohberger. Like, how would that say that's somebody else? You know what I mean? Now, is it suspicious? Yes. Is it weird? Yes. Are those Dylan, Bethany, two young ladies who maybe went through quite a bit of trauma that night? I would 100% believe so. And people handle trauma differently. Now, we spoke about what she mentioned or what Ann Taylor brought up, right? Ann Taylor had mentioned in her in the documents that Dylan had stated, I don't know. I didn't know what was real. I didn't know if I was dreaming. I didn't know what was real or not. Are those questions that are, why she didn't call during that 8 hours? She didn't know what was real. She didn't know if it really happened. I mean, there's a lot of things that go into play with why that 8 hours happened, but you can't get caught up on that. That's just one aspect of it. You have to look past it. We have to look past it and say, all right, what happened? We have at this specific time that we have a crime being committed. During that specific time, Bryan Kohberger's out and about in a vehicle that matches the vehicle that is seen at this odd hour at night during the elements with his phone off. And come to find out, the killer leaves an item behind, and that has his DNA on it. I mean, those things you need to ask yourself. Those are the questions you want to ask yourself. Like, if you're thinking Bryan Kohberger is innocent, how is Bryan Kohberger innocent with those things being true? And I mean, you really have to come up with a fantastic story for it to be anywhere near, I guess, possible. Very unlikely, very unplausible. Let's see. Hey, Steph. Yeah, we got to do it again. I know. So I'll probably do this weekend. I'll probably do a show where I can get some panel folks coming on. We'll get some people joining the stream. I'll see if I can do it on the TikTok as well. But we'll get some people coming on, and I have a way so that way you don't have to show your face on there. But do be advised, if you're watching this on like the TikTok, that's the only platform that's probably not going to be able to hear Steph talking or the other person. So I got to figure that part out. That may be just a YouTube show where we bring on calls and or persons onto the channel. And so let's see, what else do we have here? How many other questions? I am quite a few bit behind. 700 people in the YouTube. We got, I'm not even sure how many people out here in the TikTok and on Twitter and everywhere else. I want to thank you guys. Please hit the like button, hit the subscribe button, ring that notification bell, share it. Let's see. Idaho is known to settle with pleas. Maybe. I'm not familiar with Idaho that much. I know that they sentenced Daybell to the maximum punishment. Chad, not his wife, but Chad. So he got the full on long of the law put in him for what he did. So Ethan being on the floor blocking it from opening was a lie. I don't know. So as I mentioned before, and I've actually said this before a couple of times, is that when Christy told me this, what she had told me was that Hunter Johnson had told her husband during the celebration of life that he was called over by one of the girls, walked into the house, couldn't open the door, was able to open the door a little bit to see what was going on, and or saw the scene, said, "Get out," and then police were called. When Christy told me that, she told me, she's like, she said, I was told that by Hunter Johnson. And she said, but I don't know, because I was also told that she was somewhat in the hallway. And those were the two things that she was told. Now, I went with what she said Hunter Johnson said to her husband, due to the fact that came from a first party source, so to speak, right? Now, I did acknowledge, and I did say to the folks a couple of times that you had two very emotional people in Hunter Johnson and in Steve Goncalves during this moment. Locked. Could those things have been misheard or misunderstood? Yes. There's other things that could have been misunderstood and misheard, but I don't think it was a lie. I just don't know how accurate it may have been. I haven't seen the scene. From that aspect, I have seen, like I mentioned this before, I've seen certain things, but I've never seen the actual like the whole scene or anything that of Xana's room. I don't know where they were. Don't know exactly who was on what. If Ethan was on the floor or in the bed, or if Xana was in the hallway or in the room. PCA says it's in the room. She was in the room. But I mentioned this maybe about 4 or 5 different times now that I'm not familiar. I'm not 100% on that. I don't think it was a lie. It wasn't a lie by who told me. And I don't think Hunter was lying. I just don't know if there was some sort of miscommunication or misunderstanding. Like I said, this was very early on in the after this occurred, and this was before Bryan Kohberger's arrest. This is, if you go and watch this celebration of life where Hunter Johnson talks, you can tell that young man saw something. He went in that house. That has been confirmed that he was the person that went into that house and discovered them. He was the friend that was called. Now, what he saw and what he said to Steve, I don't know. But if you go and listen to that, his speech, you can tell that young man saw something horrific and that he was dealing with that very, very, very much so then. I'm sure he still is, to see your best friend in that manner. But I wouldn't say it was a lie. Okay, let's see. Stephen asks, so still no news about the August 21st, 2022 police pullover of Bryan Kohberger. Ellie will not release the police body cam footage, citing it's part of an ongoing investigation. Well, I don't think we're going to see anything, even when we do see it, I don't think we're going to see anything spectacular in that. I doubt it. I mean, I've never seen it myself, but from what it sounds like, based on the documents, all of that traffic stop is going to do is going to show that Bryan Kohberger didn't have a front license plate. Bryan Kohberger was in charge and in possession of his vehicle, and that he was driving it alone. That there wasn't somebody else that he had lent the vehicle out to. It doesn't sound like there's a lot to that, but I mean, I could be wrong. I could be wrong. 1 second. I got to do something on this TikTok thing. There it is. All right. Yeah, I agree. And so we'll do this probably for another about 5 minutes or so, guys. The knife holder is what got him. The sheath. I agree. I mean, I do think that he would have eventually came out and I do think that he would eventually came up. However, I don't think that they would have had enough evidence to have convicted him. But I do think based on his behavior and stuff like that, 100% somebody would have said, hey, you need to look at this guy. He drives a vehicle very similar. You know, they look at his phone records. They're probably going to see that his phone was off, but they don't have any other DNA in that house that matches up to him. And they don't have anything clear that shows it's his car, like a license plate or a video or picture of him. That's going to be hard. My Rostoffa says, no, she said vacuum. Now, the only reason I bring this up is because some of the folks who think he's innocent, like Myra Foster does, they'll go into saying that, oh, Dylan said this and that, and it was wrong, and it was wrong, and it was wrong, until it's something that they think is in favor of what their argument is. Like, for instance, it's a vacuum thing, not a knife sheath or a knife handle or whatever the case may have been. And I just find that funny. You know, it was kind of like when I had Delphi After Dark on the channel, and he believed that Richard Allen was innocent. And he stated that the girls who were walking, so for those that aren't aware of the case, the part that I'm referring to is the fact that there were some witnesses that saw Richard Allen, who was convicted of taking the lives of 2 little girls, on a trail, and they saw him entering the trail as they were exiting. Now, there was 4 different girls, and 3 of them have testimony statements that contradict each other. One of them says he was wearing a black jacket. One says blue. One says he was, average height. One says shorter, taller. It's kind of all over the place. And the reason being is because the only interaction that they had, and the only consistent interaction, is that one of the juveniles said hello to this person, and the person rudely just walked on by. I believe it was 2 of the victims specifically talked about that encounter. And that's just the problem with eyewitness testimony. Now, that eyewitness testimony at that moment is going to be unreliable, as opposed to if something was happening to them. for instance, like with Dylan, stuff was going on, like, people's lives were being taken. So she might have a better accurate memory than what somebody who is not prepared to remember anything, who's just going by the motions, talking with their friends, and see somebody walk by. So with Rick Snee, he was like adamant about how inaccurate that these young ladies were who walked right by Richard Allen, but was set on the fact that a witness that saw a person on the bridge, on the walking bridge, on the Monhon High Bridge, from over 50 yards away, who briefly saw the suspect, who said that was a younger person. Now that person, 100%, they knew that witness was right on. It's not Richard Allen, because it agrees, because that witness testimony agrees with what he was trying to say. The other ones, he's like, and I even told him, I was like, hey, if you say that, because one of them kind of described Richard Allen, and you can say that the person who was really close to him, if their testimony is unreliable, why are you saying that the person who saw the same guy for a brief amount of time, but from a further distance, is more reliable? You can't. And that's kind of the same situation here sometimes, where I'll say, we'll see somebody say, like, for instance, the girls, Bryan Kohberger, there's no blood in the car, there's no blood in the no DNA, none of this stuff. He had 7 weeks to clean it, but he didn't do it because there's no blood. It would have been impossible. Yet Dylan and Bethany only had 8 hours to clean up and do whatever it is that they were going to do that would have gotten them scot-free, right, in a crime scene. They had less time in a bigger place. The crime, they had the entire home that they had to make sure their involvement wasn't picked up, and that includes phone activity and things to other people, or whatever the case may have been. Any other activity or involvement from other people, right? Because we're not hearing about any DNA under the fingernails of any of the victims, or any of those things, blood from a suspect or anything like that, outside of Bryan Kohberger's DNA on a sheath. Now, yes, there's blood on a handrail on the first floor, but that could have been there from who knows when. There isn't any blood on the bodies of the victims underneath the nails, something that you would describe from a defensive wound. Those things aren't coming out. So, with that being said, somebody would have, you have the DNA on the sheath. That's what you go with. That's the only thing that's there, unfortunately. Let's see. Apparently someone was blocking Xana's door. That's kind of what was said to me. Hey, how's it going? Hunter Johnson was still in shock. Yeah, 100%. And, like when people say that there was this group of people that were out there and they saw what had happened, or they were, involved in the case, they were somewhat, involved in the murders per se. To say that you can look at somebody like Hunter Johnson and see his reactions of a person who saw the crime scene, and you think all these other people are just that callous, none of them are going to have a similar response. None of them are going to have anything like that. There's just going to be like, I think even one of them said, one of the Kohbergers said that one of the college students that was involved in this was like eating a sandwich while this was going down, the Jack in the Box sandwich, that somebody ordered the Jack in the Box so that they can frame Bryan Kohberger because he was a Jack in the Box driver. I think that's what they said. Like the theories just go on for days. It's weird. It's crazy. Whose blood was dripping outside? If I had to take, well, obviously it was probably either Xana or Ethan's. It was from that bedroom. All right. Why won't Ellie release the footage then, in your opinion, of the traffic stop? Because there's a gag order on the entire case and anything that has to do with it. I think also if you go and try to find the call logs from Moscow or even Washington, I think even in Washington, the call logs from like November 2022 through a certain date, you can't get to because they have something to do with the case. Take that for what it is. Let's see. Let's go on. Thank you, Steven, for your $10 super chat. Off topic, Fields or Wilson starting next year. Man, I don't know. Like, if my choice was between those two young men, I'd probably say Fields. But I don't think it'll be either one of them, to be honest with you. Thank you for your donation, though, but I don't think it'll be either one of them. Let's see. The person who saw a younger person saw him from much further away. Exactly. That's what I was saying. Like, he saw him from further away, and yet that testimony was solid. And the persons who were mistaken that saw him closer, well, it doesn't fit the narrative, right? Let's see. I got a $5 super sticker. I want to make sure I'm not missing anything else. From Sirius with a super sticker, thank you so much. And then we also have Mountain Mama coming in with her 23-month membership. Love my turkey family. We love you back, Mountain Mama. Thank you for coming in and tuning in as always. Let's see. I heard from a few sources it was Ethan's body partially blocking the door. That's what I heard too from my interview with Christy a couple of years back. She told me that's what was relayed to her from a conversation between Hunter Johnson and her husband. But even she says she wasn't 100% sure how reliable the information was because she was told something else differently. And I mean, if you have somebody who says that they saw something, and and let's just think about it out loud. So she says that Hunter Johnson told her husband this, right? And what would make you consider that information to make you not know, right? Would a random Reddit post make you question Hunter Johnson's story? No. Who would make you question that? It would have to be a law enforcement thing. So she's never told me law enforcement told her this or not, but this is just me speculating and connecting dots together. At one point, law enforcement did talk to them. When the gag order happened, they stopped. And so they don't know much more than what we know. But at one point they did. Would they have known that information? I'm not sure. I've never even asked Steve either about that. I've only talked to Christy that one time about that situation. I have not asked Steve. Maybe I'll give him a text message and ask him about that. But to me, if there was something that was questioning what somebody said they saw, it would have had to have been a reliable thing. So maybe law enforcement were the one that said that the door was open too. So I don't know. They didn't know 100%. I went with what the most first person story that they had or information they had given me. Let's see. Nice show again. Thank you. Appreciate that. Will I cover the Idaho firing squad procedure? I can. I'm not familiar with it. I think that is now the first thing to happen, right? I think that was the last thing that I had heard was that they had made that the they made that the hey, what's going on, Terry Blue? I see you on TikTok. How's it going? I thought they made the firing squad the number one method before lethal injection. I could be wrong, but I thought I read that. Let's see. Hope he doesn't plea. I want all of the evidence that come out of trial. I do too. Just another EXMO. What's going on? Shoulda LCSW. How you doing? How's everybody going on the TikTok? Hope you guys are doing well. This is my second TikTok live. I'm going to be going TikTok live way more often. So if you're following me there, I'd appreciate that. Looks like we have like 400 people in there. So thank you guys. Appreciate that. Or 400 likes. 9 people in there. Wrong one. Backwards a little bit. But we've had 428 people come on by into the TikTok. So thank you, TikTok. We appreciate that. If you have questions about the Bryan Kohberger case, please send them away. I'm very familiar with the case. For those that are new to me on TikTok, I've spoken about it since it happened. I've had conversations and interviews with victims' family members and other folks that have assisted us with this case and building out what the truth is and finding the truth for the victims. Yeah, this thing is under a gag order. Nothing's going to be coming out anytime soon, but well, soon enough. I do think that this case is either going to get pled out or is going to trial on time. I highly doubt that this Judge Hippler is going to expand that. I doubt it. I don't think that's going to end up happening. I seriously doubt it. He seems like he's on his P's and Q's there. Man, I need to figure out how to use this more, the whole live TikTok thing. But I want to say thank you to everybody. I want to figure out how to make mods on that. Justice for the victims. Yes, 100%, Trish. 100%. 100%. Trial's less than 6 months away. I do. All righty, guys. Well, that's going to end up doing it for us tonight. I want to thank everybody for tuning in on all platforms. Also on X, it's still called @Drunkturkeyshow. So make sure you go and check us out there. I just did the whole little thing. I should be getting my blue check mark here in the next couple of days or next day. It's under review or whatever the case may be. I don't know how long it takes. I just did that yesterday. So check me out there. Let's get that going. If you guys are on TikTok, please go follow my TikTok if you're watching this on other platforms. Under Daniel_drunk_turkey. Daniel_drunk_turkey. That is my for the TikTok. I'll be putting some TikToks on there and probably doing a couple TikTok lives here and there just to kind of get that following going as well. Let's see. In the Chris Watts case, everything. Yeah, more. Florida is a really good one to show everything. Some places don't show anything. Look at it in Delphi. They didn't even televise the trial. So I'm just glad we're getting to see it. But we'll see you guys next time. Until later. Peace out, y'all.